I think for these matters, hopefully Senator Skinner, Assemblymember Bryan can join us, Professor Ochin, if you guys can hear us. First, let's do a few updates and administrative matters. We need to approve the minutes from our September 2024 meeting. I move to approve those minutes. Will somebody second that motion?
Second.
Any opposed? Okay, the minutes are approved. Now we move on to a brief legislative update and an update on crime data from Tom. Tom, take it away.
All right. The legislative session is over, and here's where we ended up with 5 things that happened, including that were signed by the governor and will go into law starting next year, including a bill from Assemblymember Bryan that is sort of related to our expiration of lead last year and allows officers to divert people instead of arrest. A bill from Assemblymember Ting that sort of creates post-conviction resentencing procedures and allows easier access to records from CDCR and requires courts to give updated paperwork after resentencing quicker in certain cases. And there was a bill from Senator Minjavar that addressed competency to stand trial based on a committee recommendation. And the core of this bill was that a court, after finding someone incompetent to stand trial, which means they have extremely serious mental health issues, now has to consider whether mental health diversion or some of our other responses make more of an appropriate outcome than just sending them immediately to the state hospital. There's also continued funding for the MCRP recommendation we made a few years ago. And there's also a follow-up, I think our second follow-up bill on our recommendation around some license or some traffic violations. So all in all, I think a great year, thanks to the folks who worked with Natasha and Danica who helped us do this, and all the different lawmakers and their staff and everyone in the legislature. So we'll see how we shake out next year. Okay, crime.
And I think it's worth saying also, in total, I think that's 20 or 21 bills.
I think that's right. Yeah.
That we've recommended or developed here have become law. So that should, it's a real accomplishment. So thanks to everybody, especially staff, for helping pull that off.
Now, I just want to talk about the latest crime data we have. So this is data that's reported by local law enforcement agencies voluntarily to the FBI. So it's a little bit random of who reports. But we have data that goes through the end of June of this year. We have violent crime and property crime. And what we're able to do is divide out the California cities, which is about 50 cities with about 10 million people, from the other cities in the US, which is about 180 cities with around 60 million people, just to give a sense of the scope. And we can see what's going on with overall violent crime and property crime. So this is the first 6 months of this year compared to the first 6 months of last year. And, many caveats, of course, this isn't final, it could change, but this is where we are. I thought it'd be helpful. Okay, overall, violent crime is down about 3% in California, down around 7.6% in the rest of the country. But we see huge drops in murders, a 20% decline in California, 15% decline in rape, almost 5% decline in robbery, and then a 1% decline in aggravated assault. Similar or bigger drops in the rest of the country, but things are going in the right direction, I think. And property crime is an even better story, where we have basically a 10% drop in property crime in California and 11% in the rest of the country. And we see every category of property crime has gone down, except for arson. There's very few arsons, so that number is very sensitive. But we see larceny, theft, which includes shoplifting, and a bunch of other theft crimes down by 10%, burglaries down by 16%, and car theft down a little bit. You'll notice car theft is down a lot more outside of California. I think that's because it went up a lot more in those other places first. So they have more of a correction to make. But that's just a peek at overall crime trends through the middle of the year. And, as always, we'll update next time we get a batch of data. Any questions about those or anything? Okay. And now we're going to move to the rest of the proposals for the report for this year. What we're going to do is focus on proposals from the last meeting we had, which is around innocence and wrongful convictions. We're going to spend a little bit more time on those because the committee hasn't had a chance to come back to that topic since September. And then I'll go very quickly through the remaining proposals from the earlier meetings around DUI and asset forfeiture and some of those topics. So we'll sort of have a medium level dive into the innocence and wrongful conviction stuff and go much quicker through everything else. Then we'll pause for public comment and then come back for final discussion and final vote on what staff should write up for the annual report. So we have 5 proposals related to innocence and wrongful convictions. The first is about the standards for relief in the habeas and motion to vacate statutes. Just to refresh everyone, this is what we learned last time. This is the current state of the law. There's, at least 3 substantive different legal standards, depending upon whether you're in custody, out of custody, what the type of claim you're bringing is. It's quite complex. It really, there's no logic to it, I would think, at the end of the day. What the staff proposal is that instead of having all these different standards that are, depend upon, where you're filing, what the claim is, all these things are really about, you have new evidence that wasn't presented before. They should all use one standard. One of the standards that's already in the law is that you can get your conviction vacated if you show a reasonable probability that the outcome of the case would have been different with the new evidence. This would make things much simpler and make folks who are wrongfully convicted and innocent in many cases have a better process in court. So any question? Yeah.
Just to clarify, this is to get relief to get your conviction vacated. This is not about compensation or declaration of actual innocence or anything like that.
Exactly. This is sort of step 1 in that process, which is wiping away the conviction. Then you can take those other steps after that. But this is just to get the conviction done, and then there's different decision trees after that for sure. So reasonable probability is the lowest standard in the law. It's less than a preponderance, which is about, you have to show 50% and a feather is the legal cliche. But it's a standard that's applied in 4 other states, at least, for these claims. It's applied in many places throughout California law, and indeed already in the habeas statutes for certain types of claims. So we propose, let's just unify them around one standard, make things much simpler.
And we want that the result of the case would be different, as opposed to did not commit the crime or no crime was committed, or
Exactly right. Just to get the vacator, the conviction vacated, not necessarily for anything else.
Okay.
All right, so I'll move on. Number 2 is a similar, very technical thing about the current habeas laws. And this is to clarify that strict procedural rules shouldn't result in dismissal of good claims just because it's your second habeas petition or you didn't bring it in time. So right now, courts, can dismiss your attempt to get your conviction vacated, even with new evidence, and even with evidence of innocence, if you filed it untimely. And of course, there isn't a specific time period specified in the law, so it's a indeterminate standard. Or if you didn't bring all your claims at one time, a court can say, well, you should have brought this earlier or with your other claim. And of course, that does make sense. You don't want to have endless litigation with people bringing frivolous claims for all time. But what we would propose is that if you show by preponderance of the evidence and that the outcome of the case would have been different with this new evidence, then you can overcome these procedural bars. So if it's your first petition under the first standard, it's a lower standard, reasonable probability. If it's your second petition or it's untimely somehow, you have to show a little bit more to get your conviction vacated. But we're not going to kick people out because
why would we have
hard
different
rules.
standards? That doesn't. And why would it be harder to get over the?
Because it's your second petition. So this is if to observe you sort of existing law around people. We don't want them to file 20 different petitions. So you make it a little bit harder.
I oppose.
So then there would be no procedural bars ever.
No, on claims of actual innocence, if on the merits all you need to prove is a reasonable probability that you would, and the conviction is vacated and you are released, it shouldn't be harder to do it because you've filed the habeas petition or somebody else filed the habeas petition. If you're innocent, you're innocent. The conviction shouldn't stand. The conviction shouldn't stand. That's
what, again, I think we're blending innocence and wrongful convictions a little bit.
Okay, if it's sufficient to throw out your conviction, it should be sufficient to overcome a procedural bar.
Okay, that will encounter some resistance from people, but sure.
I don't think that you can make the procedural bar should not be harder than the merits of the claim.
I mean, that's a pretty common dynamic in this area of the law. I certainly hear what you're saying, but this, this isn't something that we
No, I
would be an
understand.
outlier on for sure. But fair enough, we could just say there are, right, I guess we'd have to workshop a little bit, but essentially you just have to show the same thing. You can get multiple bites of the apple.
Yeah, there's no bar on claims of wrongful conviction. If you prove that more likely than not, I mean, excuse me, by reasonable probability that the conviction should be vacated, you're entitled to habeas relief, period.
Yeah, I just think the concern will be, you know, lots of new meritless petitions that are making that claim. Whereas if you make it a little bit higher, you kind of are preserving the existing balance, but making a little more favorable to petitioners. But look, that's that's the direction we go. That's the direction we go for sure. That's just a little bit of the thinking about making two different standards to preserve the existing dynamic a little bit. Any other questions from anybody on this one? All right, number 3, this one's pretty straightforward. Specify that courts can dismiss criminal cases as a remedy. So, we've been talking about vacating criminal convictions right now. What a court arguably can do under current law, because the penal code is so broad, as we see here, it says the court can fashion relief as justice requires, would be to specify that courts can dismiss a case instead of just vacating the conviction. So if a conviction is vacated, the prosecution often has the opportunity to decide to prosecute the case again. And this would allow a court to say, no, the case is done. It's dismissed with prejudice. And that decision from the prosecutor can sometimes take months or years to be made. So it can really be a hardship for a person who may be innocent. This would be totally discretionary for the court. It wouldn't be required. So it would only probably happen in cases that are very clearly involve innocence. All right. Any questions about that one? I'll keep moving. Number 4 is expanding post-conviction discovery. This one's a little more complex. It's got a few moving parts, so we'll walk through it. But to set the stage, right now the penal code has a limited right of discovery for people who have a sentence of at least 15 years for a serious or violent conviction. And if you're planning on filing a habeas corpus petition, you can go get from the prosecutor, after you try to get it from your defense attorney and at your own expense, you can go get what you would have gotten at trial the first time. So it doesn't include things that developed after trial or anything having to do with, for example, the Racial Justice Act, which we were just speaking about. And the proposal here has 3 parts that I'll get into. First is there sort of would be an ongoing duty from the prosecutor to disclose favorable evidence post-conviction, whether there's been a request or not. This is based on a rule from Texas, actually, and it would cover things that would relate to both the conviction and sentencing. So it wouldn't just be related to, whether you did the offense or not. And then instead of 15 years before you have the statutory right, it'd be any felony conviction where you got at least 1 year of incarceration. So it wouldn't be anyone convicted of a felony, but you had to have, at least 1 year of time on your sentence to be eligible for this. So you'd significantly expand. You could take advantage of this request of the file. And then the last thing would be to allow prosecutors who are working conviction integrity units, CIUs, to be able to use subpoenas and other investigatory tools that they would in a normal case, but they can't when they're investigating innocence cases often until there's sort of a new court number. So we see all these things working together to expand post-conviction discovery. And this is—
Can I ask one quick
a little more
question on that,
detail.
Tom?
Yeah.
How is the first rule different from just what Brady requires?
Well,
The
Brady
ongoing
doesn't
Brady obligation.
I think it's very unclear, and in fact, it probably doesn't, that Brady doesn't apply after the trial. And also there's this, very complicated materiality requirement, and I think this would be much simpler. So you wouldn't have to do that materiality analysis, and it'd be clear that it actually applies, unlike Brady.
Yeah, I think it's a very open question and complicated question about whether or not Brady applies post-conviction. Courts would probably not enforce it, but I think it should, and certainly in the spirit of Brady. So I see this as kind of codifying that post-conviction Brady obligation.
Yes, and again, it's a Texas rule, so you know we are a little bit behind. I'm sure if we talk to practitioners in Texas, they would tell us all kind of horror stories, but nonetheless, the rule as written looks pretty good. And I think you know there had been discussion last time to expand this to include relevant rulings under the Racial Justice Act. It seems only fair to tell people they might benefit from. And the other thing I want to make sure to mention on expanding the current statute. So this sort of Brady thing we're talking about would not require a request from anyone. It'd just be if the prosecutor learns this information, they have this duty to disclose it. Number two is the sort of modifying the current statute where you do need to make a request to receive anything. But we'd say, okay, well, let's not arbitrarily say you have to have a 15-year sentence. You know, that's obviously just arbitrary. But let's include anyone who got a sentence greater than 1 year for felony case. So it would include people who just got straight probation, for example, which, as we know, is most felonies. And we would also make sure to say that you have, as part of the disclosure, you have to turn over jury selection notes. So right now, prosecutors argue that those are covered by work product privilege, and you have to fight to get them, and doesn't really seem to be appropriate given how important those things can be for showing racial bias in jury selection and similar things to that. So we would just say those are not work product. Those have to be disclosed as part of it, just resolving that statutorily. And the final one is just, the different tools that conviction integrity units can use: subpoenas, search warrants, and access to confidential police records, which are, brings up things around the Pitches statute and things like that.
What precludes them from using that currently?
Because there literally like isn't an active case number. That's what we've heard, is that they don't have like something to fill in on the paper.
They don't have a court
something.
or a judge to go to ask for this information. It's only after a case is initiated that they're able to, this is at least what they say, that they're able to subpoena documents.
They can subpoena during an investigation, and they can do search warrants without a case being filed. But I mean, I don't think it's a bad rule. I'm just curious why it's not what's already happening.
I share a little bit of your skepticism. I'm always like, well, have you tried it and been rejected? Like, show me that ruling. But at the same time, why not make it as easy as possible? All right, we're moving quick. Number 5. Now this is compensation. So this is a whole different process. Everything we've been talking about up to now has been about essentially going to court, getting your conviction vacated in court. Now, this is the process we have where you go to the Victims' Compensation Board and you say, I'm innocent, meaning this offense didn't actually happen, or if it did, it wasn't me who did it. And if they grant your claim, you get $140 per day of incarceration if you were convicted of a felony. And that's it. Lots of states do a lot more than that, from simple things to like adjusting that for inflation to all the way to what New York State does, which is you just have to show damages straight up. So, if you were, for example, if you were assaulted during your prison stay and you suffered special harm, you could get compensation for that. Or if, you can imagine sort of it's the general kind of tort damages situation. So, in the memo, we sort of went through and looked very carefully at what other states are doing. And what we did is we divided our proposals here kind of into 2 groups. One are staff proposals to sort of increase the amount of compensation and what is compensated, and to address some process issues that I'll go through in a second. The second group of things, which are not on this slide, are much bigger proposals that the committee had discussed in September that I think we need to talk about a little bit more, because they all have in common, or they all fit into a bucket of either raising the cost of the process significantly, increasing complexity, or sort of just, I don't know, are controversial. It's kind of one word for it. So what we want to sort of talk about these in 2 steps. So first we'll talk about the things that I think are much more straightforward, and then we can go to the ones that are a little bit more, probably require a little bit more discussion. So the first ones, the more straightforward ones, first around these process issues. One, the statutory scheme, it's been updated every year for a number of years, and it just has gotten to be a mess, to be candid about it. And we would like to suggest that we sort of go through and just, remove some of the complexity, some of the repetition, and just make it much clearer to read and consistent with other areas of the law. The second is to expand a presumption that is in the process to more cases. So the presumption works like this. If you get your conviction vacated on habeas corpus, and then the prosecutor dismisses your case, or you have a trial and you're acquitted, there's a presumption you're going to be granted compensation unless the attorney general, the prosecutor, proves otherwise by clear and convincing evidence. And we would say that presumption should also apply if your conviction is reversed on direct appeal, or if you're acquitted after an initial trial. There doesn't really seem to be any reason to treat these situations differently. And again, there's an opportunity for the state to challenge that you're innocent or not, but it just shifts the burdens a little bit, and it would make more sense to treat all these situations similarly. A third item here is to allow a family member to pursue someone's claim if the exoneree actually dies. So again, just sort of borrowing general kind of probate principles, and to say the claim doesn't die with the person if they aren't able to get compensation. And then these next are basically all things that other states are doing, and sometimes many other states are doing that California hasn't quite done. And I'll go through them very quickly. And this is all having to do with the amount of compensation, which is just to automatically adjust the compensation formula for inflation, $140 a day. I can't quite remember when that was set, but it was not recently. Create a look back period for folks who applied under the old scheme, where the amount you could recover was capped at $10,000. Or even before that, you had 6 months to file a claim. Right now, the statute of limitations is 10 years. So you can imagine a lot of people just weren't able to, or not a lot of people, but some significant number of people weren't able to get a claim in time. Reimburse any restitution, fine, fees, and court costs that the person had to pay. It seems very straightforward. Similarly, paid child support that the person was supposed to pay during incarceration. Pay attorney's fees and costs that are incurred by counsel for doing the compensation, including the pro bono attorneys. So you would just, establish an hourly rate, and the attorney keeps track of their hours and then get compensated. So if they only do 6 hours of work, they would get compensated for that. If it's more involved, it would be a higher amount. And then this last one is what a few states have done, which is, waive in-state tuition at universities for exonerees and their children as a way to better address these harms. So that was a lot of information. I think one by one, they all kind of make sense, but any questions, thoughts about any of that? Again, these are the proposals that we think sort of are very straightforward, make sense, relatively uncontroversial.
My only question is on the second bullet point of number 1.
Mm-hmm.
What happens if one count of 10 is dismissed on appeal?
That's a good question. I mean, I think you could then, off the top of my head, I think it would just be the usual rule. You can try to go get compensation. It's a very easy case for the state to say, well, no, you're not actually innocent. Look at these 9 other things you're still convicted of. And hopefully people would not abuse the system in that way.
So
you're saying all counts have to be vacated before this would kick in?
I guess that's my question.
Yeah, I hadn't thought about that. I suspect, I think that makes sense. Or we'll think about it some more, but that's a good hypothetical.
Does anybody else have any questions or comments about these? All right. You want to go to the more controversial ones?
Yeah, everybody buckle up. Okay, here we go. So there's 4 things here. Number 1, allow innocent people to claim specific harms beyond the daily rate. So this is sort of the New York system that I talked about, where you just say, here are my damages. You have to prove damages, and it could be significantly higher, work out to significantly more than $140 per day. It could, if you can imagine all the different ways you could prove damages, but I think the one that is most salient, is if you were assaulted while you were in prison, and let's say now you lost use of a limb or something, that seems like it should be compensated more than just $140 a day for something that wouldn't have happened but for the incarceration. And I think what
Would
we
that be in addition to the like, would that be in lieu of, you would have a choice to either just take the 140 a day or approve these, or would it be just everyone would have to prove damages to get damages?
I think that would be a good way to do it. The first thing you said, I think you could opt in, or maybe there's you get at least 140.
I would lean
and if you
toward
can
that.
go
Like,
beyond
you know,
that,
it's basic, just the fact that you're incarcerated is worth an X amount per day. And
right.
then if you have additional specific damages over that, because not everyone will be able to do the
Right.
work behind putting together damage.
Absolutely. So I think it would be right in addition to that base rate. That's the way to structure it. And there was also discussion at the meeting in September to allow family members not just to bring the claim for someone who is, deceased, but to essentially bring their own individual claims for harms that were done to them by the unlawful incarceration. Our hesitation here on the staff side is this, which would be extremely complicated. As I think many of us know, the family dynamics for a lot of folks who've been incarcerated are very complicated and fraught. And especially if you're talking about a long period of incarceration, this could be very tricky to work out. Doesn't mean we shouldn't do it, but it seemed to be worthy of additional discussion. And, one
Maybe
thing
we could do a similar framework where, if you have children, we presume it damages them at a certain rate per day, or if you have parents, and then if you have unique or special different circumstances, you can establish those, but there's sort of a presumption that families are damaged by incarceration, and we set a rate.
Yeah, one thing we struggled with was like, how do we, and it just is very, very complicated. How do you define what a family member is, honestly? But
and something to keep in mind too. So I have some thoughts about like, well, do you get more money because you happen to have kids? I mean, I understand, and so on the one hand, I have reservations about that. On the other hand, I think that there are real damages to happen to kids. We all should also keep in mind that this does not preclude, and this is not a substitute for tort litigation against somebody who might be responsible for that wrongful conviction, in which case all these damages are collected.
I
think the
true.
damages should go to the kids, not to the incarcerated. If we show that the kids were damaged, or were you envisioning it would go additional damages to the person who was wrongfully?
I don't know. I thought that you were suggesting that, but in any event, regardless, to prove you could. This is not a substitute for tort liability and recovering that way.
Right.
So this would be compensating children. We said it, and Heidi, you're suggesting a default number that you could prove more damages if need be.
If we were gonna go this route, I mean, I really like the provision on the last slide that their children get to, go to California universities, because there's so many damages and disadvantages that build up for children who are people who are incarcerated. It would be nice to do something along those lines. I don't know. I haven't thought much about whether it's money or it's but if we are going to do something like that, maybe rather than having to show it, it's easier just to have a presumed amount, but you can go above it if you can show something specific or difficult about the circumstances.
And I think the children's situation, that's sort of relatively cut and dry, but when you get into sort of spouses, I don't know. That's where I think it can get very complicated. But if we sort of we don't have to solve all those issues in making a recommendation either. Okay, any other thoughts on number one here? I'll move on to number two. Number two is allowing claims for all unlawful incarceration. So as I said at the start, to get compensation, the standard is that the crime didn't occur, you didn't do it. So this would be a little bit different. This would be people whose incarceration was too long for some reason. And, we identified three categories here. The first is the sentence was unconstitutionally excessive because it was cruel and or unusual punishment. So that would be very few number of people, but essentially a court saying you never should have had this long of a sentence in the first place. It's disproportionate. People would be compensated for that excessive time. The second category would be conduct that is no longer criminal. I think the best example here is what we were talking about this morning with the accomplice liability for murder. So if we said you are no longer guilty of murder, any incarceration attributed to that could be compensated. Or the final category we were thinking about would be a sentence or conviction that violated the Racial Justice Act. Similarly, a determination by a court that this sentence shouldn't have been as long. Now, this is really mixing innocence with unlawful incarceration in a way that I think to some might be inappropriate. We weren't able to find any other state that did this, with the exception, I think Ohio will allow compensation for a conviction that's vacated because there was a violation of Brady against Maryland, very specific. But there was sort of no comparable regime in any other state. Any thoughts or feedback on this one?
I'm of two minds. I do think that there's something about clean and pristine about having this about innocence. On the other hand, if a court says that your incarceration was unconstitutional, was illegal, or the legislature has since said, we don't want to keep people in prison for this, I sort of think you should be compensated for that. I think that that's the same kind of harm as a wrongful conviction. Now, taking out, an innocence conviction, taking out that the person who's actually innocent has further remedy for negligent behavior that might have resulted in that wrongful conviction. I think that's what separates innocence cases. So
I would
I
encourage us to at least think about whether this would put any kind of this would inhibit some of the criminal reforms we're all here to think about. It's going to add a huge cost if, every time we do a 1437. I don't really know how to evaluate that, but I just raise it for our consideration.
Well, if we limited it, for example, the first bullet, that would, a constitutionally excessive sentence. Those are not something the legislature weighs in on. That's, all done by the courts and would be a much smaller group of people. But, almost what's the point, honestly? But
I think what Heidi's suggestion is that courts would be reluctant to grant a motion, if they knew that this was a financial reward coming. Is that what you were saying?
Courts, yes, especially the legislature on the second two bullet points, but yeah, true for courts as well. Maybe not quite as strong of a anti-incentive.
Yeah. Well, the legislature could always say, well, for this particular change, we're not going to allow compensation. Right? You could.
True. Well, it sounds like we should just nix this one. That's the vibe I'm getting. Just to keep things moving. We can come back to it, but that's maybe where we'll leave things at the moment. Number 3, this is something that was discussed in September as well, which is the state currently pays for the compensation process and the actual awards. In fact, it used to be the legislature had to pass a special bill paying individual people. That was changed a few years ago. But they're paying for harm that they did not create. It's local actors, often police departments or, prosecutors' offices that are the ones that have actually created the wrongful convictions, yet they are not bearing any of the costs of the compensation process. So you could try to get reimbursement from those actors to the state, just to sort of more properly apportion liability. Now, this would be the hesitation we had on the staff side was the complexity. How do you, figure out exactly who did what and to what percentage? But look, it happens. And the current system right now is no fault. You don't actually have to prove anyone did anything wrong, just that you are innocent. And this would shift that dynamic a little bit. And I think because of that, it would also increase the sort of the adversarial nature of the proceedings, because it's hard to imagine that the localities would not try very hard to be involved in the actual compensation process. And it would take this relatively simple, straightforward process we have and, add all those complexities to it. So that's the situation on that one. All right. Reactions from anyone? Good idea, bad idea? Neither.
I think this was Senator Skinner. I thought that you had interest in this particular issue. It seems difficult. I share some of the administrative concerns that were raised.
Well, some of this, the first slide that had some things that we could do to improve compensation aren't fully overlapping on this, but had some things that in a way account for this without being as specific. It doesn't deal with the allowing innocent people. It seems to me there should be the attorney fees aspect.
Right.
That should be included. And Tom, if you don't mind, go back to the slide. There's a couple of
There's that one and this
so that
one.
yeah, no.
Okay.
Yeah. All right. So in here, it would be there'd be a inflationary adjustment, so that would get it up some. There would be the look back for those who were previously capped. It does have some support for children in that it could provide the in-state tuition waiver. So I like that without it being, I mean, I think that they should get the, children should get additional compensation because if they had a parent who was incarcerated, then it's affects, obviously that's an income earner that, I mean, there's so many factors, but independent of that, this at least does cover some. But I think beyond child support arrears, I think there might be included in here other debts that were accumulated, because that's one of the things that occurs to even people that are released, even that weren't wrongfully convicted, face huge debt because while they were incarcerated, they couldn't deal with whatever debt they had prior. So I think there's some things in the subsequent slide that could be put into here that would flesh this one out more.
Yeah, and I think those the dynamic that Professor Rummel was talking about being able to prove additional damages encompasses a lot of that too for the family members. That'd be a good way to, we can have these specific categories and then you can go beyond. All right, let's talk about the last one, which is attorney's fees, but this time not for the compensation process, which we think is more straightforward, but for work done to obtain vacature of the conviction. So that, you know, can often be extensive investigation, litigation involving many years, but would encourage more of those types of cases to be done.
Well,
if
and that's, I should have been clear because that is what I was referring to. I think we definitely should add that because
okay,
absolutely the attorney's fees involved in proving your wrongful conviction should definitely be covered. If your wrongful conviction was then proven, it's like any type of court case. In a way, we require the one who lost to cover the attorney's fees. So in this case, we should do the same.
I feel strongly about including this. There are so many people with wrongful convictions waiting for representation.
and you know, we're thinking just, I think we all are on the same page, but you know, including pro bono attorneys, aka innocence projects and clinics and stuff like that, would be able to get compensated. Okay, well, that's Mike. Sorry.
Anyway, agreed.
Yeah, though it gets a little bit tricky if counsel is already assigned by the court, but we can, I think, put that aside a little bit. That's it on those topics. So here's where I say, I think on these, the sort of straightforward compensation proposals, I think we're good with all those. On the more tricky ones, on the first one, I feel like we ended up saying there's the base rate, and then you can prove beyond that at the claimant's discretion, basically, including harms to family members. And we'll have to, I think, defer to other areas of the law for how family is defined. California's done some work on that recently. On number 2, I'm hearing no, let's just stick to innocence at this point. Number 3, I didn't hear sort of enthusiasm for trying to, really get localities to pay back. But number 4 is a firm thumbs up, and that's, attorney's fees for vacating the conviction, not just the compensation process. Any objections? All right, great. So we will now go to a summary, a very quick summary of recommendations that we otherwise considered. So we're almost at the end, folks. We're almost there. And this is the list. I'll just go through them very briefly and see if there's any questions or concerns, but we really have talked about these a lot. So unless there's questions or anything, I think we can move pretty quick. So we have the DUI, asset forfeiture, and some other proposals. DUI number 1 is lowering the per se BAC blood alcohol content level to 0.05 to 0.08. I think the committee, our impression on the staff side is that the committee is not ready to make this recommendation at this time, but because we've spent so much time on it throughout the year, we just wanted to sort of make sure that was correct and close it off for now. So unless anyone wants us to write that up and pursue it, we will assume we are not doing that. But just wanted to have the space to clarify or have a different understanding. Okay, the other DUI proposals are presumptive diversion for most first-time offenses, essentially any first-time offense where you haven't caused injury. Support for collaborative courts, meaning suggesting there be a better funding stream, and also that collaborative courts can waive some of the mandatory sentencing requirements for second and third, et cetera, DUIs. And the 4th is streamlining license suspension so that people don't get their license suspended twice in sort of a patchwork fashion. It should just happen once, and that's it. Okay, that's DUI. Asset forfeiture, 2 pretty straightforward ideas. The first is amounts below $10,000 cannot be civilly forfeited, meaning there would have to be a criminal conviction before they could be forfeited. And why we picked $10,000, we did a little bit of data analysis, and it turns out that this would account for about 70% of forfeitures, but only about, 8 or 9% of the overall amount of money actually taken. And even in those amounts below 10,000, about half of them were done with a guilty plea, so it would be with a criminal conviction. This wouldn't apply to. But this would be a way to sort of increase the due process around this practice that our research showed is much worse in other states than in California, at least from what we could tell.
And I don't remember where we came down on this, but why exempt any amount at all? Like, why shouldn't we just always require a criminal conviction?
I think there is, it's building off existing law that has these different, procedural rules for different amounts, but whatever. The reason they have those is I think there's sort of a presumption in the law that higher amounts of money are more suspicious in a way, that, if you do have $100,000 in cash, along with on your way to an illegal marijuana grow operation, there's sort of a, and of course people can always challenge the forfeiture. It's not automatic. It's just a matter of balancing how much protections are provided at each level. But that's the idea. But again, this $10,000 amount would apply to 70% of forfeitures already. So it's a pretty big, it's getting pretty close to doing that. And the second one here is expanding the use of funds to crime victims. This is a very modest proposal, no pun intended, but it would allow some money that's set aside for police officers explicitly say you can also use this to support victim services. Right now it's limited to, I think, anti-gang and drug abuse prevention programs. So that pot of money would get, a little bit more eligibility for crime victims. All right, and the other 2 proposals we had were to allow and specify in the penal code that prosecutors can do diversion programs for gun possession offenses at both the misdemeanor and felony level. This is based on a program out of Minneapolis, I believe, that's had really good results about getting folks, at this moment where seems to be a real sort of important intervention moment for folks who illegally have a gun, and trying to help them avoid that kind of behavior and similar in the future. And the last is this issue around credits for folks with life sentences. there's litigation that the credits created by Prop 57 currently cannot apply to reduce their minimum eligible parole date. And that seems to be an incorrect interpretation of Proposition 57, but it's going to take a few years for that to be worked out in the courts, even if it is eventually overturned. So that the legislature should try to do as much as it can in the penal code to remove any barriers that are preventing those credits from applying. And, we're still waiting to get a little bit of data from the Board of Parole hearings about exactly who is most affected by this, what the offenses are, and I think that will determine what the exact statutory fix. But I think the committee should just sort of make a general recommendation that the penal code should be updated to the extent possible to, return to the status quo for these folks who also had extremely low recidivism when they were granted parole. All right. And the last thing I wanted to mention, and the last few years, we've had an appendix to our reports that have listed offenses that no one has been arrested for or convicted of. We aren't able to do that right now because of some data limitations that actually we're working out, and we plan on doing a sort of a standalone report sometime early next year and bringing that up to date. So, so make our PDF about half as long as it usually is. But don't worry, same number of recommendations, just less tables at the end. Okay, that was a lot. Obviously we can go back to any of these, but Assemblymember Brian, yes, sir.
Yeah, no, I just wanted to say one more time. I know we talked about it during that meeting. Deep concerns about the 0.05, mostly just the net widening concern. I mean, we know that DUI is one of the most common things people are arrested for or have contact with law enforcement for. We know that the increased likelihood of those encounters are in the same places. There's an increased likelihood of law enforcement encounters, period. And so I'm just concerned. That one gives me some concern. I understand the potential public safety benefits and some of the data that was presented to us in that meeting. I remember very well. I had some just concerns with it then, but I just want to put that out there one more time. It makes me nervous, even with the presumptive diversion for first-time offenders. That also, as a recommendation, makes me nervous because I remember seeing a bill sponsored by the folks who do the in-car breathalyzers, who were sponsoring this bill to ensure that everybody had to use one, and that ability to pay. It was a component of it, all this kind of stuff. We ended up not even hearing it in public safety in the assembly because it felt a little bit greasy. So just that section of our work this year still makes me concerned, but I think we've done a pretty good deep dive, and it also was incredibly eye-opening. So just wanted to register those concerns, but grateful for all of the areas we've covered this year. That's a hell of a range, by the way, from DUIs to asset forfeitures to all of the different areas we covered today in our criminal law class. Thank you all for this work.
Yeah, well, thank you, Assemblymember Brian. I think those concerns about DUI exactly why we're sort of hitting the brakes, I guess, pun intended, on that one. And I hope that this is something we can sort of return to maybe as there is more data or other developments. And I'll also mention on the IIDs, the ignition interlock devices. As we've been writing this up, we've always said current law on that should stay the same, which is that it's at the discretion of the judge, and I expect that's what will be in the final report too. But thank you for flagging that as well, Professor Ochin.
Well, first I want to say thank you to the staff for this, for the great summary of the recommendations, and for the work that you all did to make it possible. I just wanted to amplify my agreement with Assemblymember Brian. So I won't say much more about that. I did want to say on the issue of the procedural hurdles for folks who are litigating innocence, actual innocence claims, and I know we we're talking about whether to extend that to all unlawfully incarcerated people. With respect to the RJA, I hope that as we talk about the RJA, we will, circle back to that.
Got it. And Judge Espinoza has his hand raised.
Yeah, I just want to see if I understand. If we abandon the idea of lowering the blood alcohol level, are we still considering going forward with presumptive diversion for first-time offenses?
Yes.
Okay, that's all. I think that's a really critical, needs to happen thing. Most people just get one deuce, and it should be divertible, and there should be a presumption it would be divertible. Okay, thanks.
So we're going, and on that note, it's a funny thing. This is we almost have this diversion dynamic for these offenses right now, in the sense that our automatic record clearance laws will, I think it's within 2 years, automatically seal these convictions anyway.
Okay.
So, we kind of are getting there in a kind of a roundabout way, where the conviction is sealed pretty quickly. You have to do all the other requirements, which we would suggest as part of diversion. So this might just be a way to be a little bit more efficient about what we're doing. The California Policy Lab actually also just put out a report about the scope of those record clearance laws, and I was shocked by how broadly they apply. Shocked in a good way.
Yeah.
So I wanted to mention that as well. Okay, so now we have to do public comments. And then we'll sort of return, I think, to the open issues around some of the earlier recommendations, try to see if we can sharpen those up a little bit. If not, that's okay too. But then we have to have an actual committee vote that these are the recommendations, and we'll have the massive mega slide that has everything in one place. So we'll return to that in a moment. But Mike, is this a good time to do public comment?
I think so.
Okay.
So
Yeah.
we've reached the time for public comment. If anyone is there in person, is anyone there in person?
I don't think so.
I don't think so.
Just-
For those
just-
listening on Zoom,
There's no one here in person.
thank you, Megan, for being there.
Megan, you're a person. You count. There's no one else.
I
there.
count, but
Okay.
And you're welcome to make public comment, of course. But for those of you on Zoom, please select the raise hand function. If you're calling in, please hit *9. Note that this meeting is being recorded, and if you might want to make a public comment, your name and/or phone number may be displayed as part of the recording. We'll take a minute now to see how many people want to make a comment, and based on that, we'll see how long each person has. Please note that we accept a public comment in writing. Comments can be emailed to committee staff, and their emails are on the committee webpage. I do want to also say that public comment should be limited to the discussions that we had today. So let's see who's in line.
We've got Crispy and Yolanda. Let's get started with Crispy.
hi, my name is Crispy, and I'm going to be reading comments from incarcerated people. From Kenneth Moore at California Men's Colony, implementing a retroactive code for striking gun enhancement would allow our community here the opportunity to serve, help, guide those in society that are struggling with underlying issues. I respectfully ask you to consider my comment, and I appreciate you for keeping my loved ones safe in society. I accept full responsibility for all of my criminal behavior. This one's from Ronald Montez, also from California Men's Colony. He's an Initiate Justice Senior Inside Organizer. Regarding wrongful convictions, the district attorney's office is withholding evidence and coaching witnesses what to say on the stand. They're also taking defendants into courtrooms where the judge is one of their best friends, not to mention 98% of judges are ex-district attorneys. There's no way a defendant can win. From Michael Singh at Richard J. Donovan Correctional Facility. As we speak, there's 2 DOJ investigations at women's facilities, CCWF and CIM Chino, regarding systemically sexually abused women, Dublin Rape Club type acts. In regards to privacy, prison guards are deemed public officials and inmates' faces can be blurred. If there's nothing to hide, then this will not be opposed. Let there be public viewing transparency. And thank you for all the work that you're doing, and congratulations on all of the legislation that you have had passed. I know that I've worked a lot on some of those too. So it continues to be the thing where you get this legislation passed, but then none of it actually, actually gets implemented. And it's frustrating, and I see the frustration in your faces as well. So I hope there's some way that we can manage to implement some of these things, especially the Racial Justice Act.
Thank you, Crispy. I think you read our minds on the implementation. It's at least half the battle. So, and thank you for continuing to raise up voices from folks inside. We appreciate your participation in our committee.
Yolanda N.
Hi, first off, can Tom, can you read the phone number for people to call in? Because I have other advocates texting me asking for the phone number to call in.
I think, Mike, that's should be right in front of you.
I do not have.
Oh no, it's I'll grab that as you continue your comment, Yolanda.
Okay, great. Thank you. I just want to applaud everybody on the panel and thank you for all your work. And I just want to bring back the LWAP second look at. Can we revisit that, or where did we leave off with that? Because 30 years is plenty of time. 40 years is plenty of time. 25 to life would be a good basic, and it wouldn't cost the state so much money. So that's my public comment. And again, thank you for what you do.
Thank you. Thank you, Yolanda, again, for being a longtime contributor to our work here. Tom, do you have that phone number by any chance?
Yes, this is also on the agenda for the Penal Code Committee meeting today. I'll just read it from there. 669-444-9179. And if it asks for an ID, you can give it 818-7106-1684. And again, this is all on the Penal Code Committee's website for the agenda for today, but happy to give it out again, of course.
So here's what I propose we do, especially those who might be calling in. I'd like to take a 10-minute break. Tom, can you then prepare the slides that we'll be voting on? And then we'll take a vote. We'll come back from the 10-minute break. If there's any more public comment, which if somebody wants to call in, please do so in 10 minutes. Now that you have the telephone number, we'll hear those calls then. If not, we'll just proceed directly to the slides and the vote. Does that make sense, everybody?
So 250?
250, thanks.
But what about my reply? You always reply.
Oh, I thought I said, I thought I said thank you, and I very much. I mean, your reply on the LWAP. I mean, it's a perennial issue for us. I think it is for you as well, and something that I think that there is receptivity to it. I forget where our current. I mean, we made a recommendation on it, and it just has not been picked up as legislation, which is a shame. But I do think that there continues to be interest in the issue, and we continue to be push on it. And then I should also say that, like, listen, you have been here, I think, almost every one of our committee meetings pushing us on that, and it's part of the reason why we haven't abandoned it, and we haven't, I promise. So
Thank you.
sure, of course. With all that said, let's come back at 2:50, and hopefully if anybody wants to call in, they can call in then. If not, we'll take Tom, if you could take that time to prepare the slides, and we will make our vote and conclude the meeting. Thanks, everyone. All right, if everybody could come back to their desks.
I'm here. I'm just away from my screen. Thanks.
As long as I'll get the last final Ark of the Covenant slide up here.
All right. I can't see who's here, but Assemblymember Bryan and Professor Ochin, if we could have you, if you're around.
I think they're both there. I know Professor Ochin
that was just me. I was just speaking. I'm here.
Oh, I'm sorry. Sorry.
Remember Brian's.
Yeah, I'm around.
Excellent.
Okay, great. All right. All right. Now that we've heard public comment, well, first of all, is there anybody who's called in for public comment?
I see one person has called in. I think they need to press *9 if they want to get in line for public comment. Okay, they have raised their hand. They're done it. So I'll let them talk. So this is
right.
phone number ending in 504, which is my area code where I grew up.
Thanks. We have 2 minutes. Hello?
Hello, this is Joanne. Joanne Shear calling in. Hello, it's really good to see everybody, and thank you so much for this really, really important committee hearing. I was very, very happy to see that their felony murder aider and abettor liability is being talked about and recommended by this committee. I so appreciate that. And so appreciate seeing Senator Skinner on here and all of her work around SB 1437. It has helped so many people. I just want to bring to the committees, and I know you probably already know this, but when we're talking about accomplice liability for implied malice, particularly under felony murder, the wording of major participant reckless indifference brought about after SB 1437 is the exact same language that was taken from the special circumstances 190.2D. It is the exact same language. So as a prosecutor, there is no bar to scale. There's no hill to climb to move a person from a first-degree felony murder conviction, a first-degree murder conviction, as an accomplice from a 25 to life sentence that you get from a first-degree felony murder as an accomplice to a death penalty or life without parole enhancement, because that language is exactly the same now. So I just want to bring it to the attention of this committee, and I know you probably have talked about this, but I didn't hear a lot about that in today's discussion. There is no narrowing now for accomplice liability between 189E3 and 190.2D. And that, to somebody who is serving a life without parole sentence, to have a 25-year to life sentence and the opportunity to go before the parole board after 25 years, particularly as most people are under the age of 25 when they receive a felony murder conviction. This is a very, very low bar for prosecutors. And judges are not, when people are going back for evidentiary hearings, we call it justice by geography. It really depends on what county you are having an evidentiary hearing in. So I would greatly appreciate a conversation around about that justice by geography. If you're out of LA County, you have a much harder road ahead of you in an evidentiary hearing under 1437 than you do in, say, Alameda County or Contra Costa County. That's just the truth of the matter. So I just want to greatly appreciate you all for this conversation. I totally agree with Professor Rummel and Ocean, and I think Senator Skinner and Assemblymember Bryan, I think many of you have decided not to put a third-degree murder up as a recommendation, that you are recommending eliminating the accomplice liability or perhaps the expansion of manslaughter to cover those bases. So I just want to appreciate you and thank you very much for this conversation. And that's all I wanted to say. So thank you.
Thank you, Ms. Shear. I am also sharing some of your concerns, particularly about the justice by geography. One of the things that I think Tom and I were talking about, and something that I think that we should perhaps consider next year, is that CDCR used to use, is this right, Tom? Am I remembering our conversation right? The CDCR initiated resentencing to try to even out some of the disparate sentences by geography. So, for example, if conviction for robbery was netting much longer sentences by one county than another, then CDCR would recommend resentencing in those cases. Anyway, for another day, but it's something that's definitely on our radar. So thank you very much for calling in. So now that we've heard all from public comment, is there any
Michael,
more? Yes,
Mike,
Senator Skinner.
on that, since my
Sure.
assumption, given my appointment, that I would not be continuing after, well, probably after November 30th, but I wanted to bring up that on this justice by geography, one of the things that, well, financial, if counties are made to feel the impact of their decisions financially, it could change it. And I think it's worth it to put on the committee's radar, especially if Prop 36 passes, that we could obviously, we understand that there may be a great deal more three-strike sentences. Three-strike sentences are obviously extraordinarily expensive. And there is no, right now, counties are not held financially responsible at all for any type of disproportionate sending of people to state corrections facilities versus putting them in county jail. And while realignment, in effect, was designed to help cover their costs, if they, if people go to county jail, so there was, we did some financial things for them. We've never made them have to have any responsibility for if they have a send people disproportionately to state prison. And given that we will likely see our state prison numbers go up, and at least, the finances could change, but we were in a deficit in the last budget that I at least voted on, I adopted. So some of these kind of financial discussions in relationship to our sentencing practices might be worthwhile. And of course, I think in any way we discuss it in any kind of reporting, we shouldn't talk about it as justice by geography, just because that is not necessarily the right way to frame it from the point of view of acceptance, but rather just that that financial type of responsibility.
Yeah, I think that that's a good point. And we've talked about, financial incentives in a number of different contexts, the juvenile justice context, SB 677, 678, I think was also another financial incentive that really did seem to change practices on the county level. I do think I don't want to get too far sidetracked by this, but even within jurisdictions, large jurisdictions like Los Angeles, at minimum, judges should know what the sort of average sentences are for the crimes that they're, before them. I think that would be extremely helpful. And like I said, I believe that it's the case that CDCR used to play that policing role, not in a financial way, but at least keeping an eye out for sentences that seemed inconsistent with the norm, and would recommend that those cases go back to court. Anyway, that, like I said, for another day, but Senator Skinner, especially with your recommendation to think about the financial implications and being able to incentivize counties that way, I think we should, definitely keep it in mind.
And maybe it could begin by just a breakdown, over the next couple of months, staff or one of our partners could compile a breakdown of sentences by county.
Yeah, we can do that. We're going to be busy in the next month or so with this report, but yes. All right. No more public comment, correct, Tom?
Correct.
All right. Now that we've heard public comment, we'll take a formal vote on what recommendation should be in this year's annual report. Based on that vote.
Can I make one other suggestion? I know we have this final list before us, but I wondered if we could slightly modify the issue under accomplice liability so that, yes, and accomplice liability for implied malice, but to continue to explore language. This would be our direction to staff for when it comes back to us, to explore language to ensure that a conviction for second-degree murder, which has an indeterminate sentence, so a sentence that could be 15 years to life, that it have some standards that it would have to achieve to get that. So in other words, high standard of reckless indifference to human life, something about knowledge that your actions would likely lead to a death.
Okay. Well,
So that reflects what we had been discussing.
yes, I think haven't we also suggested to go even further than that, Tom?
Well, you mean for this coming report or for future?
For this report.
Where would that be? But it's not in this, what we would be adopting today. And that's why I was trying to modify it so that we were giving staff direction for what we're adopting today, which comes back to us in final.
Okay.
So that's what I've highlighted at the green here, is where I think there's just maybe 30 seconds more discussion about exactly what direction we should go on these three. The rest of them, I think we're good. But I think when we ended or paused the implied malice accomplice discussion, you laid out sort of three options, Mike, and Senator Skinner had said, or we could sort of have a fourth one where we, those options were just end it, done, third-degree murder, or sort of end it and don't address it at all. And then Senator Skinner had suggested, I think, a similar thing of maybe laying out different options for filling the void that ending accomplice liability here would create, which could include sort of a sentencing enhancement that would attach if the offense ended in death, or a manslaughter definition. Sorry.
Well, what I'm arguing here is that we definitely end accomplice liability for implied malice murder. However, when we, I don't know if this falls a little differently, but second degree murder with indeterminate sentence, you can get a life without it you being quote unquote accomplice liability. You see what I mean? So I was trying to add to this that we would that you would still, in order to get an indeterminate sentence for a second degree murder conviction, you would have to have, there would have to be qualifications or precondition of knowledge that your actions would very likely lead to death. So that gets back at our notion around, because before we were talking about, hey, there shouldn't be any, that we needed to like revise the whole murder statute, which I do think we should. And we go back to the model penal code for any murder conviction. However, this is just a bit of a variation on what we were discussing earlier today.
I'm still a little confused, honestly. Rick, did you?
Yeah, I think Rick was going to say the same thing as me. Yeah.
Yeah, it's just that the state of the current law.
I think maybe the senator's talking about framing this as an extension of 1437, which is, it's our recommendation that all murder convictions have an intent requirement, intent to kill, or reckless indifference to human life. So we may want to, that will keep the door open for us to go broader so that we can think about how implied malice works in our system. But within that stated purpose, we can, for the time being, end accomplice liability for implied malice. We can get rid of felony murder in provocative act cases, but it kind of gives a coherent theory to what we're doing, even though at this point we're only in a position to recommend these specific fixes. I don't want to speak, I want to jump in for you, Senator Skinner, but I think this would be a logical extension of what you started with 1437.
Right. I can't speak as articulately in terms of the codes and the legal language, not being a lawyer. So I think that you captured what it was I was trying to articulate. So
I spent a lot of years teaching criminal law, and you try to explain to, I mean, you can't even explain to law students how someone can be convicted of a crime they didn't intend to do. Like it's fun, it's so fundamental. But yeah, I think that's the recommendation I would be most comfortable with, because I think it keeps us open to continuing to fix these little, these little exceptions to the general principle that you have to intend a crime to be guilty of it, to be culpable for it.
My only hesitation is if we include the reckless indifference, I don't know, that
I think that's the next step, Tom. I think we
taps
need to think
into
a lot
a
more
big
about
vein of,
that.
right, exactly. So I'm
I
a little
agree.
hesitant to
But I think if we
approve
set
that.
the tone, no, I agree. I think if we set the tone of, look, we believe that California murder law and all law should reflect that someone has to have an intent to commit the crime that they're convicted of.
Right.
Here are some problems we see in that general rule and that we're going to fix now. But I think what really the problem is implied malice and the way it's defined, and all these other problems are sort of stemming from that. So I would be in agreement with Senator Skinner that we would continue to think about and address how we define implied malice. And I agree with her also that I think ultimately, if you don't intend to kill someone, you should at least have reckless indifference to human life in order to have any kind of a murder conviction. And then short of how we address whether you have a assault that results in death, the resulting in death enhancement, or something else to recognize that people who engage in the same criminal conduct, sometimes it results in murder and sometimes it doesn't, and we think about those crimes differently. We could also save that part for another day. But this way, we're not just sort of, it feels a little less piecemeal to me, and a more coherent strategy of what we're hoping to accomplish.
Tom, does that make sense to you?
Yes, but I think it doesn't resolve maybe the question of definite consensus on ending accomplice liability for implied malice murder. But then does the committee want to say something about the sort of consequences of that, either being, and that then sort of creates the need for some new offense or sentencing enhancement to address some of those cases, or just let existing law apply? And
I don't think we've identified any gaps where existing law doesn't give, sufficient culpability for someone who engages in a crime that results in death. I think for now it's okay to end accomplice liability within the greater framework that this committee is going to look at crimes that don't have an intent requirement, that skip over intent in some meaningful way, like Senator Skinner started off with in 1437. That was the big problem we tried to tackle with that bill, and we got most of the way there, and now we're just kind of closing up these little loopholes.
So just to understand what we're narrowing down to our recommendation, that the ending accomplice liability for implied malice, period. We talked about, and I think this is what Tom was getting, is in the body of so that would be the main recommendation, that the legislature may want to consider, for example, adding the sentence enhancement, or expanding, I suppose, the manslaughter definition to make sure that there are no cases that slip through the cracks. Or we could just eliminate those sub-suggestions and just end it at end accomplice liability for implied malice, period.
I think that should be the recommendation. If we have to take compromise positions along the way, we can consider those other options. But I think we should have a consistent position that people need to intend the crimes they're convicted of. And ending accomplice liability is the simplest way to do that.
I agree. Senator Skinner, does that?
Sorry, just on that point, I also want to emphasize, I want to make sure that I understand whether this is correct. Under this theory of accomplice liability, the accomplice can be subject to a higher form of penalty than someone who would have been the principal under this theory. Is that right? So, for example, the person doesn't intend to kill, they did not actually kill, they were not the person who killed, But under SB 1437, if the person didn't intend to kill, right, and they actually did kill someone without the requisite state of mind, they wouldn't be subject to second-degree murder under felony murder, because they would have to prove reckless indifference, right? But under this theory, they can still be held responsible if a death occurred during the course of some other crime that they did intend to commit.
Yes, but they would, for it to be under the implied malice theory, they would need to have done something with a high possibility of causing death and known they were doing that and done it anyway. So it's not that there's no intent requirement, it's that what you intend is not to kill, but to do something that is very likely to kill someone. So that's why it's a little.
But we're not talking about the person who killed, the person who had the implied malice. We're talking about someone who was with him in another context,
right,
and attributing the implied malice of the perpetrator to the accomplice.
Correct.
I don't think the accomplice could be held liable more seriously than the
no, not in that
perpetrator.
situation.
Right.
I think in some other situations it's possible that an accomplice can be held liable for, more, but in this situation, there's no longer any imputed malice. The actual accomplice who's convicted of the aiding and abetting implied malice murder has to personally harbor their own conscious disregard for life. It's not imputed from the actions of the perpetrator.
Exactly. Well said, Rick.
Right, which is why we can eliminate this.
Yes, that's not it.
And why we don't need to create
a gap filler.
Yes, because
right. We don't need a gap filler.
Yeah.
Well, let me make the argument, play devil's advocate a little bit on why there's some reason to do that. Like one of the cases I read last night, where this theory was upheld, it was a group of 5 or 6 people who were alleged to be in a gang went and teamed up, beat up one person, and then someone in the group stabbed the person 4 times, and the defendant then kicked the person in the head multiple times after the stabbing. And the question was, the person who did the kicking liable for the implied malice murder and accomplice theory? And the court said yes. And I think that gives a flavor of sort of, this is not folks typically who have very minimal involvement in these offenses. So I think.
But Tom, in reading that case, did it include whatever it is that was there? What other options the prosecutor might have had to go after that person? And so I think to look at it
absolutely, yeah.
Right, that we would be eliminating this, that thus there would be no other consequence for this person's action. I think
right, he would be guilty of assault with great bodily injury, and if the jury found that the kicking after the stabbing demonstrated reckless indifference to human life, he could be convicted of murder. But they would be making a determination about what he intended at the time that he kicked the person, and there's going to be serious consequences for all of those crimes. But if he didn't intend to kill him, or really realize how hurt he was, or think he was going to die, then it would be a whole host of other crimes that would be sufficiently punishable. But there's no reason that because someone else stabbed him, he's responsible for those stabbings. He's responsible for his own actions, given the situation, as it occurred.
Yeah, no, absolutely. I'm just trying to give a sense of, the facts of these cases tend to be a little more, I don't know, I think I said unsavory earlier. And that's, why a court may say, yeah, this was murder. But, I think we've ventilated it pretty thoroughly. I just want to make that last point that, it's that tends to be the common theme of reading the cases.
Sorry, I know we've been airing this out, but just digging into the criminal law weeds a bit, it seems like this is an end run around causation, not the state of mind, right? Because they're not demonstrating that the kick to the head caused the death, right? That's the issue, is causation. And so they're using the implied malice theory to get around having to prove that this person who maybe did have the state of mind that would otherwise qualify for second-degree implied malice murder on their own as the principal caused the death, right? Because that's an element of the crime. And so they're using implied malice murder to get around the causation element.
That's correct. And I
Yeah,
think to
that's a
Tom's
good point.
point, I think that the jury is going to be given this case, and they're going to be asked to, as Jennifer Hansen mentioned, like courts are struggling to identify exactly what was the act. And so a jury may be asked to say, or the prosecutor may say, look, this person who participated in this beating, but and kicked the person in the head after they were stabbed, that their actions directly caused death, that this group, and they would identify the action as kind of this group assault, not necessarily specifically the stabbing, but this group assault caused the death. And when the only option for the jury is to say yes to that or no murder, then it might be a more difficult question, to say, okay, if I don't agree that that action caused death, then he's just off the hook for murder. A jury might have trouble with that. Whereas if there was a step down that said, okay, well, I still want to convict of murder, but I don't want to make an all or nothing decision.
But that doesn't actually solve the problem, because even in a third-degree murder situation, they would have to prove causation. And if you can't prove causation, you can't convict them of anything, right?
It would just be
Involuntary manslaughter or third-degree murder or second-degree murder, because that's why they're imputing the conduct, the physical conduct of the principal to the accomplice, because they can't prove that the accomplice's conduct actually caused or was, either the direct or proximate cause of the death, right? So that to me is the issue. It's causation, not the state of mind. And so, and one of the basic principles that we are I think trying to articulate here is that the prosecution has to meet their burden to prove every element of the crime. So in the 1437 context, the issue was the absence of a state of mind, because you're imputing state of mind based on the fact that they were committing a separate felony, right? So here, the issue isn't the absence of the state of mind. They may have been doing something that, if they had directly caused the death, might be seen as reckless disregard for human life, but they can't prove that the person is the one that caused the death, because it was a group of people. And so they're using this theory. And so this has the same problem, which is that it circumvents a central element of the crime, which is causation.
Actually,
And
I
they
think
always have
the stabbing pretty
conspiracy theory
clearly caused
liability. We always have, I mean, if they can prove
Right.
that, the group agreed and intended to do it, but yeah, I agree with Professor Ocean.
All right. Well, I still don't, it sounds like we're not going to suggest filling the gap.
Yes, the recommendation remains the same, which is ending accomplice liability for implied malice murder under the discussion is the general principle that
Right.
people shouldn't be held liable for crimes that they did not intend.
And also that we shouldn't allow the prosecution to obviate or, their burden of proof with regard to every element of the crime. Because again, the issue here is, as I think Rick and Tom were saying, the person might be acting with reckless disregard in kicking someone, who's been stabbed, right? But we can't prove that they caused the death, right? That's the issue, is they may not have been the one that caused the death. So that's, to me, here is the issue. It's, yes, the principle is we should not hold people responsible for something that they did not intend, nor should we hold people responsible for something that they didn't do, for something that they didn't cause. So that's the other issue.
Agreed. Okay. Tom, does anybody have any questions on this particular recommendation? Because I want to make sure we're clear as we vote on this.
We're just talking about the first
First bullet
three? First bullet, okay.
of accomplice liability. Any questions?
I think we've got
it.
Sufficient direction. And then, if there's a little bit more discussion at the next meeting on this, that's good. We just don't want to have that for every recommendation.
Agreed. And for the knowledge, for the remaining two green bullets, I thought the consensus was that we would end accomplice liability for both.
I took a look at it over lunch, our short lunch, but I guess I'm not as concerned about the knowledge requirement, the one you're changing now. I'm not as concerned about the knowledge requirement for being armed, because the idea of that enhancement is that you're armed even though you're not using the gun to either threaten someone or anything else. But I think I think what the committee had the biggest problem with, and correct me if I'm misstating anyone's belief, but I think it's the fact that there's accomplice liability for use of a firearm, that it should be, and
Let's
that
not-
only applies.
Yeah, those are two different things. Let's try to keep them. The concern with number one, the first bullet point, was not about the gangs. This is a very, the
Right.
problem with this is it's a common one. It's only 1 year, but it's a very common enhancement. And you can get it if your accomplice is armed and you don't even know that he is armed.
Right. And we talked about the difference between having, I think we, at least at a minimum, we want knowledge. I'm
Yeah,
okay
right.
with just knowledge. I'm okay with just knowledge, because if you're going on an armed robbery and you know someone's got a gun, even if you don't have a gun, it seems like the same level of seriousness. But I think the use one is where,
Right. Let's
Right.
before we get to the
So-
use, before we get. So for the now, do we want this to be mere not? So we all agree that the current state of law, which is you don't even need to know, is should be reformed.
yes.
The question is, should it be reformed to I know that the person has a gun, or that the defendant has to personally be armed, which means having the gun available. Those are A, option A is just mere knowledge. You know that your co-defendant has a gun, but you don't have access to it. B is that you have to personally have access to the gun. Senator Skinner, if you're trying to talk, you're on mute.
Just flip a coin if there's
Okay,
only two
to
choices.
get an enhancement, a firearm enhancement, seems to me you need to be armed.
All right, the mere knowledge is, you have to have more than mere knowledge. You have to actually have access to the gun.
I think
I
so.
think that makes sense too.
All right, something like this. Okay.
Any objections to that before we get on to the use? Okay, the second issue, just to tee it up, is that to get a enhancement of 10 years, 20 years, or life sentence, 10, 20 life, for using a firearm, ordinarily, you have to actually use the firearm. Rick, jump in if I'm saying this incorrectly. However, if you are convicted in an offense where it's a gang allegation is involved, you do not need to use it, know about it, anything. Just there has to be somebody else involved used the gun. You didn't know about it. And you get a very stiff additional penalty. Rick, am I saying everything correctly? Okay, good.
Yeah.
We all had a big problem with the except if you're in a gang, then you get it. And I think that the consensus was that we eliminate the gang exception, meaning you can only get the 10, 20 life enhancement for using a firearm if you used the firearm,
Yes. Yes.
including if you happen to be in a gang. You do not get a lower standard because you're in a gang. Any reservations or questions about that?
Well, in this particular situation, the gang is irrelevant. All that's relevant, at least the way I hear you, is that you actually used the firearm.
Correct. The reason why the gang is relevant because under the current law.
Yes, I know the current law. I know.
Okay.
I know. But in the way that we are recommending, it's changed.
Yes, correct. We are recommending to have it. If you use the gun, you use the gun. Doesn't matter if you're in a gang or not. Period.
Yes.
And that gets back to our serious concerns about the racially disparate use of gang enhancements. I seem to recall, just to, not to put too fine a point on it, that in Los Angeles County, it was like 98% of people with gang enhancements were people of color. I mean, it was beyond
Correct.
ridiculous. All right.
I would consider recommending that this be a retroactive. Maybe that's too much far to go, but there are so many people that takes a regular, crime, a serious crime, up to a de facto life without parole sentence because of these firearm enhancements under some of these theories. Something to consider anyway.
I think that's typically our default presumption. But you're right, we haven't explicitly mentioned that here. And I think a similar point for the ending accomplice liability for implied malice murder, those folks should probably get a chance to go back to court again, if that was the theory.
I mean, I totally agree. I think every law should be retroactive. We should in fact pass a law that says any laws becomes retroactive, and and overrule Estrada essentially. However, we should know that everybody should have availability of AB 600, although that's very discretionary. They would at least be eligible for a reconsideration of their sentence. All right. All that said, we've done a lot of work today, especially Tom and Rick. Thank you all. So
let me point out one last thing just to make
Yes.
sure. So this is on the innocence and wrongful convictions. On the procedural bars, this is very terse, but it's not, for the preponderance overcomes the procedural bars. It's innocence, and we'll develop that a little bit more in the write-up. But the
Right,
idea was that there shouldn't be a different standard for a successive or untimely petition. So
correct.
it does kind of beg the question: to what burden do you have to prove innocence then? But we'll
Reasonable
figure that out.
probability.
Okay.
That's it. Period.
Yeah.
There's no procedural bar to a claim of wrongful conviction. Period.
All right, we'll do it. But I think the rest of these are as discussed. And then the other one I would highlight, last one would be the compensation. Obviously, there's a lot of subparts to this, but I think we captured that discussion and came to good conclusions earlier, and that's what we'll write up. Oops. All right.
Okay. Before I ask for a vote, does anybody have any further clarifying questions on any of these bullet points? Okay, hearing none, I would like to move to make these our recommendations for our 2024 report, which will be drafted by committee staff and brought back for a full vote at our next hearing. Can I have somebody second my motion?
Second.
I'd like everybody to say aye if possible. So I guess I will take a roll call to make this. This is really the one vote that we really do.
And approving the report, that's a pretty important one.
Yes,
too.
exactly. Assemblymember Bryan. All right, we'll come back to him. Judge Espinoza,
Aye.
Professor Ochin,
Aye.
Professor Rummel,
Aye.
Senator Skinner,
Aye.
and I also vote in favor of the motion. Thank you all. I think it's passed.
Mr. Bryan's here
Yes.
now.
Oh, Assemblymember
Also-
Bryan, good.
Going in and out of signal, but aye.
Okay, great. It's unanimous. So Tom and staff will spend the next month or so drafting up our report. That will largely look and feel like the staff memos that you've seen on these subjects up to this date. So there shouldn't be a ton of surprises, or shouldn't be really any surprises, but it should, look like that. And we'll have a draft report ahead of our meeting. Please read that. And at our next meeting, we'll vote to adopt the report, pending any edits, proofreading, or suggestions that come up at that last meeting. Sound good? Any last questions before we adjourn? All right, Tom, have we taken care of all business?
All family business is settled. Yes.
All right. Thank you all. It's another
Thank
long
you.
but
Thanks,
productive
everyone.
day. I really, really appreciate it. Have a good day, rest of your week and weekend, and we'll see you next time. Thanks a lot. I think our next meeting
Okay.
is on Monday, November 25th. We'll see you all then.
And we'll get the draft out a week before then. So hopefully enough time. Okay, thanks everybody.
Thank you all.
Take care.